Shri Ashwini Vaishnaw ji.
Sir, I rise to support the two bills. The first bill is on amending the Arbitration and Conciliation Act of 1996, and the second one is setting up a new center called the New Delhi International Arbitration Centre. Honorable Chairman, sir, these are two great steps. These are exactly in line with our Prime Minister's vision of simplifying the whole legal system and strengthening the institutions, and wherever there are no institutions, creating the institutions. Sir, the first the first bill to amend the Act of 1996, it's a very welcome step in which an institutional framework is getting created. As Honorable Minister said, an ecosystem is getting created. I would like to strengthen that point and say that yes, it's an institutional framework. I thank my senior colleague, Mr. Anand Sharma, on very pertinent points he has raised, and I'm sure Honorable Minister would like to address those points. What I would like to speak in this House is based on my personal experience. I had the fortunate privilege of working on very complex international contracts, having multiple jurisdictions and having multiple challenges of different countries. So, for example, today's economy has become very, very complex, sir. Let's take the simple case of an aircraft door. A simple aircraft door which looks like a door which is opened has as many as 500 parts. And where do these parts come from? Something will come from Taiwan, something will come from made in US, something will come from China. It's a very, very, very complex international commercial scenario, sir. Such international and such complex and such a scenario in which there are multiple stakeholders definitely requires a mechanism which is very flexible. Our courts and our entire legal system is bound by a particular law, bound by a particular tradition, which does not have the flexibility which is required in commercial disputes. So I'm glad that everybody agrees that in principle there is absolutely no disagreement on the way forward. Yes, we need arbitration. We need a very strong framework for arbitration. This particular bill is a very good step. It's a very welcome step. And there would be many more steps, I hope, in the process of strengthening this ecosystem. Sir, one of the most prominent arbitration center was set up in London in 1892. 1892, long back, sir. It has evolved in a way where we can learn a lot from the international best practices. All the other subsequent arbitration centers like the Singapore Center, the Tokyo Center, the Shanghai Center, the New York Center, the Zurich Center, all these have basically followed what was learnt in the London Center. What are these international best practices? And what I would like to submit, sir, is that many of these points have actually been included in this new bill. That's the welcome step, sir. First and foremost is setting up a independent body which will basically regulate, which would look at, which would create the whole framework, sir. That's the purpose of setting up the Arbitration Council of India. It's a self-regulating body. It's an independent body. This body will be looking at who should be the arbitrators. This will look at what should be the regulations, what should be the process followed. This is a very, very welcome step, and I would recommend to the Honorable Minister, sir, that take this to the next level, sir. This is a great first step, second step, make it totally independent. I echo Mr. Sharma's point that definitely they should not have any government officers serving in it, sir. This should be the next step in which we should take it forward, sir. They should be totally independent. Then only the international investors or even the domestic investors will have the confidence, real confidence in the body, sir. Sir, the second and most important point is who should be the arbitrators. Internationally, if you look at it, the arbitration community basically comes from domain experts, sir. This is a norm which is followed everywhere, sir. Today, sir, if you ask the chair of the arbitration seat, what is the difference between MMBTU and what is the difference between MMSCD, if you have to explain it to that, then I don't think judgment or the award would ever be really in line with what the dispute needs. So that's why domain experts, getting the domain experts who understand the subject deeply and who understand the commercial aspects of the subject is a very important thing. This act addresses that point and creates a panel of arbitrators who will be following, who will be impartial, who would have experience and knowledge. And third thing I would like to recommend to Honorable Minister, that they should be willing to devote time. It's not a question of setting a legal bar on the time, sir. It's more important that we should have people who are willing to devote time to the subject. Today, for example, if I understand a couple of subjects and if I have to be an arbitrator in those subjects, I should be willing to put time, enough time and effort in that particular solving that commercial dispute to be able to do justice to it. So that is, in fact, internationally the three criteria which are used is domain knowledge, impartiality and willingness. Actually, written willingness is taken. That yes, I am willing to devote 72 hours per week on per month on this particular subject. That kind of
is a new member. अभी सारे सदस्यों के नए, हाँ इसलिए नहीं रिफ्लेक्ट कर रहा है क्योंकि वो नए सदस्य हैं और बहुत सारे सदस्यों के अभी वो नाम नहीं आया सूची यहाँ पे. इज ए न्यू. Yes, yes, I know. Please.
Thank you, sir. The second important point, sir, which has been brought in this bill is accreditation of arbitrators, sir. That's a very, very important fact, sir. Today, sir, if we go by the system, sir, why the system has failed? The system has failed because we had to actually file an application in the High Court or the Supreme Court to set up the panel of arbitrators. That's not the way the world works, sir. All over the world, the basic clause regarding arbitration is kept in the contract itself, sir. So that is one more recommendation I would like to make to Honorable Minister, that we need to amend the Indian Contract Act. That's a contract act of more than 100 years legacy. One way to see that, yes, it has stood the test of time. Second way to see that, yes, it has really fallen behind the way the world has moved, sir. So that way we need to amend the Indian Contract Act and have the institutional framework of arbitration within that act itself, sir. So one very important aspect which I would like to highlight before all the honorable members through you, sir, is the confidentiality of the commercial contracts, sir. So today, if you look at the global scenario, sir, Tokyo is a very important arbitration center, but it has practically failed, sir. Why it has failed, sir? Because every arbitration award, they put it in the public domain, sir. Whereas any commercial contract, people would like to keep it very, very confidential, sir. There are technical aspects, there are IP rights aspects, there are pricing aspects which people don't want to disclose, and which is very fair, sir. That's the way the world commerce works. So I'm thankful to Honorable Minister that he has brought in the clause of confidentiality in this act, sir. This is definitely going to be a defining factor in making our arbitration successful, sir. There is very important point about having electronic depositories, sir. This is very important, sir. Today in the global commerce, in fact, at one point of time in my team, there were people from 5 nationalities speaking 5 different languages. So it's very, very difficult to manage to bring everybody on the same page, sir. So having an electronic depository is a very welcome step. This must be supported, and this should be augmented by bringing in video conferencing as a very established mode of arbitration process, sir. That would be another recommendation, Honorable Minister, I would like to make, sir. Sir, today Mumbai is a well-established center of international arbitration, and with this act, Delhi will also become a very important center, sir. Today, sir, the way Indian economy is growing, sir, $2.7 trillion, our commercial complexity requires arbitration centers in many more cities, sir. So in Chennai, in Bangalore, in Hyderabad, Bhubaneswar, all these cities, sir, we really need smaller arbitration centers which should be self-governing, self-funded. Sir, I frankly don't feel that Government of India should spend even 1 rupee on any arbitration center, sir. It should be, and it can be, and it is. Internationally, it is a self-funded, self-governed body, sir. Because even if you say, sir, today must be about 40-45 lakh commercial disputes in the country, sir, which are of large sums. Even if we charge a small fee of 4 or 5 lakh rupees per case per arbitration that can really fund the entire arbitration process, sir. Sir, I would like to conclude thanking the government, sir, for this excellent initiative. I'd just like to touch one more point what Mr. Anand Sharma said regarding the seat of arbitration and the governing law. It's a very complex matter, sir. There are arbitration centers which have actually been able to resolve it in very nice way. I have a personal experience of actually having one arbitration matter in which the seat was Singapore, but the laws were laws of England, sir. So that kind of system is available in the world today, and if we can just replicate those best practices, it would be a great thing, sir. That will help, because today, sir, today in the contracts, we actually define which governing laws would be there defining the contract. It need not be the laws of India, need not be the laws of one particular place, sir. We can today define the laws of Japan, laws of any particular country as the defining, as the governing laws, sir. So this is a very important point, sir. We should definitely take it as the next iteration, sir. I would like to conclude, sir. This is a great step forward, sir. And definitely this is going to ease the way we do our commercial transactions. This will definitely reduce the load on the courts, sir, which is badly needed, sir. We have more than 3 crore cases pending, sir. This will be a great welcome step, and I request the House to unanimously support this step and definitely take this bill forward, sir. Thank you, sir.
Thank you.